Good day, my name is Mark Malore. I'm a principal here at the Malore Law Firm. I want to speak with you today briefly about commercial construction and some of the construction requirements for enforcing the payment on your contract price. Many of my clients in Ontario are having a problem in this economy with recovering the price on the contract that they agreed to do the commercial construction work they contracted to do. And that's because, that's for a number of reasons. One, the bad economy, but also because they're being squeezed for a little extra profit by the general contractor or owner. Maybe there was a mistake made, and so there's a question about whether they want to pay the full contract price. Whatever those situations are that are affecting you, I encounter them quite often, and so I want to give you some helpful tips in order to avoid those situations or some of the pitfalls that I find my construction clients having in Ontario. First of all, you want to make sure that if you're a subcontractor or materialman on a job, you want to make sure that the first time that you set shovel to the ground or you deliver materials to the project, you send out your 20-day preliminary notice, certified mail return receipt requested, within 20 days of that date. The reason why you want to do that is the 20-day preliminary notice protects all the work you do 20 days prior to its being mailed, and then on, once you give notice to the owner of the property, general contractor, and any lender with respect to the construction project. As long as you've done that, you preserved your rights to recover all of the contract price from the date you started, as well as preserved your right to do the next thing, which is file and record your mechanics lien on the project. Now that's one of the principal things that I have as an attorney to recover money for you quickly and more simply. If you have a mechanics lien that's been done properly and recorded properly, it allows me the ability to recover that contract price much quicker than I can if we're just suing based on breach of contract or some other means. Why is that? Because the mechanics lien is secured against the property itself, and so there's no ability to get financing or refinancing of the project once your mechanics lien is encumbering the property. And so there's a lot of statutory protections as long as you followed the particulars in recording your mechanics lien. Finally, I want to point out that when you record your mechanics lien, you have 90 days to file a lawsuit to do what we call enforce your mechanics lien rights. If you fail to do so, you waive your mechanics lien rights, and if you're unable to file another mechanics lien based on the particulars of the project, then you no longer have a mechanics lien enforcement action that's available to you, and you're left with the breach of contract action, which doesn't give me as a lawyer a lot of power in order to recover those funds quickly, easily, and less expensively for you. So make sure you file and send out by mail certified mail return receipt requested your 20-day preliminary notice, and make sure that you hire an attorney or file a lawsuit yourself to enforce your mechanics lien rights within the 90-day period after you record the mechanics lien on a particular project. Those two things will save you a lot of time and money and give me a lot of power and empower me to recover money for you in any subsequent litigation I have with general contractor, owner, or another subcontractor that you are a subcontractor to on any particular project. Those are important things. Think about those. If you have any questions with your particular situation, be sure and come to see me, Mark Malore at the Malore Law Firm. Thank you for your attention.